Okay. Hello, this is Module 13, Tort Liability, and my name is Shirley Basil. Okay. Okay, so I am going to define tort liability. And tort liability is an act produced by an individual under a contract that can lead to legal accountability. Okay, so teachers watching over kids when they're playing or even while in class or any type of sports, any adult that's watching them, if anything happens to that child, then yes, they could be responsible for negligence, and that would be considered tort liability. Okay. So one of the cases that I read was Johnson Johnson versus School District of Millard. So this is a case that it was decided in 1999, the verdict, but it involved a first grade boy at a school that got injured while playing London Bridge during his music class. So the plaintiff and his family, so the little boy and his family, they were awarded $21,226 in damages and pain and suffering. And medical bills. So if this were to happen at my school, a reactive measure would be for the director to have meetings with us on prevention and actually coming around to make sure that we're actually walking around our class or walking around the playground during recess just to eliminate some accidents from happening. Okay. The proactive measure would be to include information on being vigilant during classroom games and at recess. In the school's orientation every year also, we should be reminded. As teachers, yes, it's really hard to forget when you have 25 kids in the class that you should be vigilant. I mean, that's part of our job. However, sometimes, it's just a matter of being a little bit more vigilant when children are at play. And I think that should be stressed. So some professional ethnic that could have been in place here would be to stand where the kids were, where they were rocking back and forth and doing the London Bridge thing, just to assure that the kids aren't being shaken too hard and being thrown like this little boy was into a bookshelf, and kind of hit his head right above his eye, causing blurry vision. Okay, so another case that I read was the Mulvey versus Carl Sandburg High School case. So two students blamed the school district for being repeatedly bullied while playing basketball for their school. So the school district won the case because they did everything that they were supposed to do in preventing the bully from attacking or from bullying these students. At my current school, we don't have anything in place for bullying. We don't have much of a discipline system, to be quite frank. Only what we as teachers know is not okay for a student to do. For instance, I had a student who hit another student in the head with a mini chalkboard, and of course, it's just a matter of me talking to the social worker, talking to the child's parent, just so that we can eliminate this from happening again. So some reactive measures that would occur if this were to happen at my school is that depending on the teacher would send the bully to the school social worker, as I mentioned previously, so that the school social worker can contact his or her parents and so that they can get a plan in place to prevent that from happening. Some proactive measures could be to have teachers talk to the students about how dangerous it is and how, it's not okay to bully somebody. Um, the school principal should talk to the parents about bullying and explain to the parents in a meeting exactly the type of measures that the school is willing to take and that they have to take if their child gets in trouble for bullying. So the third case that I read was the Mosley versus Portland Public Schools District number 1J in the Supreme Court of Oregon. A fight between two students in the hallway. And then one student was, got so badly injured that they had to be taken to the hospital because the other student decided to use a box knife on him. The parents of the injured student sued the school because they claim that the lack of supervision is what allowed the fight to get to that level and for their child to be hurt. The court ruled in favor of the school because apparently school security was diffusing another situation in another part of in another part of the school. My school would ask 3 witnesses that saw the fight just to make a statement and to figure out exactly what happened and what was said, who started it, that kind of thing. All teachers, I feel one of the proactive things is that all teachers should be in the halls outside their classroom during class changes. You have to welcome the kids, you have to get them along, move them along to their next classes, and that does eliminate some tension sometimes when there is a teacher around. Okay, so the next case, the fourth case that I read was Rollins versus Concordia Parish School Board. A 9-year-old girl, she fell off a merry-go-round during a physical education class while a substitute teacher supervised. So the court found that the district was negligent with their supervision in that case, and the court reduced the damages, however, because they claimed that the 9-year-old girl, she was 50% responsible for her own injury because the substitute teacher did yell at the kids, or she did tell the kids to get off the merry-go-round because it was going way too fast. My school would talk to the teacher responsible at the time and the student injured and 3 other students to see exactly what happened, to compare stories. A proactive measure would be to remind the substitute teacher that she needs to be vigilant during PE and that she should create a game where the students can play together and she can kind of control what the children are doing. So during PE, at that time, they should provide it. Maybe they can provide it, an assistant PE teacher that would help supervise the children and kind of keep them on track. Okay, so the next one that I read was a little tough to pronounce, but Brahatek versus Millard School District. While in gym class, a student was struck in the head with a golf club, causing his death. The teachers were found negligent. In this case, of course, because the child died. Court was in favor of the student's family. The security and administration team at my school would investigate, and also the local police would have gotten involved to give my school a report. I would assure all students to take a safety class and sign a waiver or sign that they've read it and that they've understood it before they even could participate in the sport. So I feel like if this child, from what I've read, he apparently missed the day where safety was presented by the coaches. However, had they taken the measure to have a document where the student signs that they've read and they understand the safety precautions and what they need to do, then they would have known that this child wasn't there during that time and that he probably shouldn't have been out there playing with them during that time, and that he probably should have been taking the safety class, and maybe had he taken the safety class, he would still be alive today. So my school district, unfortunately, does not have procedural steps to follow in a case such as this. I can give you an example. Just the other day, I had a student. She fell off of the she fell off of the monkey bars and she broke her arm. And school wasn't liable for paying for anything. As much as the parent came and tried to get the school to help, um, the school just said, well, we give your child a $7,000 education a year for free. We give her uniform, we give her everything else. So now that she's hurt, because accidents do happen, you have to go ahead and handle it. So we don't really have something in place for something like that, which I think we probably should. Most countries do. So, districts should require all schools to go over safety of sports with the students in school. I think that that's so important. Before just jumping right in, you have to go over safety measures so that students understand what's expected of them, and so that you yourself, that you've gone over what they need to know and what they need to do to keep them safe. Okay, and these are my references for the cases that I read. Okay, thank you.